All right. Hello to everyone. How's it going? This is Immigration Attorney Moumita. I'm coming to you live to discuss immigration and discuss what may be on your mind. I have an important topic for you today, and that is a question I have received almost every single day. I definitely got this question several times today. And this question is I am a person who's married to a US citizen, but now we're separated. My spouse has even told me that they're going to tell immigration that this is a fake marriage or that I'm going to get in trouble. Do I have any options? Is there any help that I can get? And what I want to tell you is that, first of all, if your spouse has engaged, if anyone has engaged in a fraudulent marriage, both people will get in trouble, not just you, but your spouse would also get in trouble. But this is not the point of this. The point is that marriages are usually real. And just because somebody threatens to report you or threatens to accuse you of being in a fake marriage doesn't make it so. And if somebody is accusing you, especially if your husband or your wife is accusing you and threatening to get you in trouble, then this is a sign to me that there are some other issues in your relationship. And you may need to take the option of filing for a self petition. So, especially if you are separated from your husband or from your wife, or you are in the process of divorce, you may have the option of asking for a petition for yourself. You may have the option of asking the government to give you a green card based upon what you have gone through in your relationship, including these threats, including aggressiveness, including other types of harm, either physical or emotional. You may have the option of asking the government for relief in the form of a green card based upon what has happened in your marriage. And this may be the option even if you are also in the process of getting divorced. The main limitation is that if you have already gotten divorced, you may also be able to ask for a green card for yourself. However, if your divorce is more than 2 years old, then you may not be eligible for this relief any longer. But if your divorce has occurred more than 2 years ago, then I would still want to look to see if you qualify for other things, even if it's not necessarily this. So the point is that if you are going through threats, other sorts of controlling behavior, other harm, anything else in your marriage, then you may have the option to ask for a green card for yourself. I know many of you have gone through a lot of suffering on your own. I know that some of you may have already been told by other lawyers that, hey, listen, I can't help you. Your best option is to just stay married or marry somebody else because you need to have a police report to prove that you've gone through all of this stuff. It's simply not true. You don't need to have a police report. And this is also something that I get asked a lot. I get asked in my consultations, well, abogada, I don't have a police report. How can I prove this? But remember, the biggest piece of evidence that you have in your case is you. So your recollection of what you have gone through, what you tell us, and how, what is said in your affidavit are the biggest pieces of evidence in your case. So if you're going through this divorce, if you're going through a separation, you're still legally married, and you are having issues, you need a green card, you need a work permit, give us a call, 212-248-7907. All right. So I hope everyone's having a great day. I know that Facebook has been down for quite some time today, but luckily we have Instagram today and we have YouTube. And please leave me your questions. I'm going to do my best to answer as many immigration questions as I can in the time that I have tonight. And thank you to all of my followers. It's good to see you. Okay. I have a question on YouTube from Kenson Lewinson, who's asking, by getting an approved for an EAD, does it mean your I-485 will also get approved? From Kenson on YouTube. Kenson, thank you so much for your question. So any of you who have filed for a green card application, which is the I-485, and you have also asked for a work permit, just because you get your work permit approved, does that mean that your case for the green card will also get approved? No, it does not mean that, because you have to prove a separate set of eligibilities for the green card itself. However, it's typically a good sign that you've gotten your green card approved. Okay, let's see. I have some questions here. Thank you, Duca ESQ. I have a political asylum case granted, but I haven't yet received my green card from Nuan NBC. Nuan, that's great. Congratulations to you and anyone else who's gotten approved for their green card based upon their asylum. So here's the thing, though. If you have been approved for asylum, it does not mean a green card yet. The typical rule for asylees is that once you have been approved for your asylum case, you have to wait 1 full calendar year before you can apply for a green card. So it typically takes actually more than a year after you get approved for asylum to actually get your green card, because you still have to go through the green card process, and on top of that, you also have to wait 1 full calendar year to apply for your green card. Azar is saying, my baby is born 4 days ago and I have a green card interview in 2 days, but I don't have the birth certificate. Is that okay? From Azar. Azar, congratulations to you on the birth of your baby. It is definitely okay. You don't need to have your birth certificate for the interview. What you can maybe do is maybe take some other documentation. I know at the hospital, they'll usually do those cute little picture, like those little cards with the footprint of your baby's foot. Most people usually know that when your baby is born, it usually takes at least a week, maybe several weeks to get the actual certificate of birth. So don't worry about that, okay? But make sure you have all of your other documentation, such as your original birth certificates of yourself, of your spouse, your passports, marriage certificate, and those sort of things, okay? Hi, Nosheen. How does the spouse get in trouble when he has his papers and the other doesn't, but claiming for fraudulent marriage? From SK Nosh. All right. Thank you so much for your question, and nice to see you here. So here's the thing. When you're married to somebody and they are trying to control you, they're trying to hurt you, one of the most common threats that they will make when they are married to an immigrant is, I'm going to call immigration. I'm going to get you in trouble. I'm going to tell them that this is a fake marriage. And, let's be clear also that a lot of people, when things don't go their way, they'll also accuse you of using them, which is definitely not true. However, if they were, let's just say, even if they were to write a letter to immigration accusing you of being engaged in a fake marriage, well, again, number one, as I said, it goes both ways. So if they're trying to get you in trouble, then they may get in trouble themselves, because fraudulent marriages have severe and strict penalties. Even the U.S. citizen spouse can end up going to jail and paying a heavy financial penalty. However, especially if you're doing a VAWA case, this is part of the abuse that you might be going through with your U.S. citizen spouse. And the officers at the Vermont Service Center are well aware of this. And they definitely take the abusive behavior into consideration. Okay, SK Nash, I hope that helps. I have deferred action, though not through DACA. Can I apply for adjustment of status through the I-140 from Maida? Maida, thank you so much for your question. So if you have deferred action, you may be exploring other options to fix your status. But deferred action typically just means that you're allowed to be here, but there's no status. To do an I-140, you need to usually, you're looking to get a green card through your I-140. So that has to be done either through the process of the stateside adjustment of status, or you go overseas for the consular processing. You will not be eligible to do the stateside adjustment of status on an I-140 if you're no longer in status or you have any unlawful presence. You would probably need to do, go overseas to the consulate instead. And for that, you would most likely need a waiver. If you need any consultation on your case, give us a call. Okay, let's see. Simon is asking, my wife is in prison for violating parole. We have been married for 4 years. Can I apply for a green card, and what are my chances? From Simon. Simon, I'm sorry to hear that your wife is in prison. If you've been married for 4 years, your relationship and your marriage is a bona fide good faith marriage, you should still be able to apply for a green card. However, if your U.S. citizen spouse has certain criminal convictions, this involves anything having to do with basically sex crimes, sex with minors. If your U.S. citizen spouse is a registered sex offender, then they are typically barred from applying for anyone else ever. Okay, it's a very serious crime. It's a very serious thing. It is called the Adam Walsh Act. You may look it up. But if your wife is not in prison for that reason, then you should still be able to proceed on your case, okay? They will have to make special arrangements because she won't be able to show up to the interview. My mother, who is a green card holder, Let's see where the question went. My mom filed for me under a married child over 21 at the time, and now I'm divorced. Can we update it, and will it upgrade to unmarried child over 21 from senior designer? Senior designer, I'm actually not very clear on that question. I don't believe that you may be able to ask. I don't know if you'll be able to ask for an upgrade because typically they look at the case at the time that it was filed, okay? Can an EAD renewal affect an asylum application? If I request a letter for case status with USCIS from UBM, UBM requesting an update with USCIS regarding the processing of an application may affect it a little bit. It may slow down, but it should not affect it severely. Congress passed legislation about Afghan parolees that applied for asylum in USCIS with an interview no later than 45 days and 150 days for final decision. Does that apply to all Afghans who apply for asylum? From Ahmad. Ahmad, I haven't heard of this legislation yet, but if Congress has indeed passed it, then it should apply to all Afghans who have applied for asylum. I see. The comment that you said, Ahmad, is about Afghan parolees. So it may or it may not. I'm not clear, but I would love for you to send me the link over here on YouTube, and I'll take a look at that. Okay. Someone who gets citizenship, their children under 18 in the U.S. without status, they need to apply for adjustment of status to get a green card first, or can they apply for citizenship immediately? From Faraz. Faraz, this is a great question because many of you are, becoming naturalized citizens and you have minor children. But the typical rule is that for you to pass your citizenship status to your kids, they typically need to be here on adjustment. They have to have been entered into the U.S. with an admission, which means that they usually need a green card. Okay. West Coast Babes is saying, I'm excited to get started, but a bit scared. West Coast, I can't tell if I've spoken with you. If I have spoken with you, then, you have nothing to lose, and you know that we're going to take care of everything in your case. My case is out of processing time. Can you help me? From Nuwan. Nuwan, this is not typically something that we assist with, but if your case is out of processing times, what I recommend for you to do is to reach out to USCIS to create service requests to see why it's taking so long, follow up with them, and if that doesn't work, then you can always contact your local representative or your congressperson to ask for immigration assistance on your case. Do both me and my older brother have to be 21 or older to help my dad start the process of getting his green card and get legal? From Alan. Alan, thank you so much for your question. So yes, anyone here, all the sons and daughters that want to help their moms and dads become legalized, you must be at least 21 years old to start the process. And in addition, you may also need to meet other requirements about income and stuff like that. But the first thing always begins with looking at your parents' case by trying to determine what their immigration violations are and how did they come into the country. Because if your mom or your dad came into the country without permission, that means crossing illegally, then they will not be really able to get your help in legalizing. And we need to look at other humanitarian cases to help them legalize. So Alan, if your parents need assistance, give us a call, 212-248-7907. If I received a prima facie in VAWA, is it normal before appointments for biometrics to get a work permit? From Jerry to Jerry, Hari to Hari, Figuero. Sorry, I'm not saying it correctly. I know it's unbelievable to get your work permit before the biometrics even, but this is not abnormal in a VAWA case, which is why it is such a valuable sort of case. So no, it's not. It can be normal. I've had this happen in many of my cases as well. I came here when I was 4 and got married, and I still haven't fixed my papers, so I hope I will. It's soon. Just scared. West Coast Babes. So definitely the immigration process is so scary because there's so much unknown and it's so complicated. I know that. One of the biggest things that you can do to help ease your mind is to make sure you're working with a lawyer who actually understands everything. They look at all the angles, they try to explain things to you, and they take the time to make sure that you feel comfortable, all right? And, once that's taken care of, the process is still scary, but at least you're going to have that peace of mind, and you know that you're going to have a quality lawyer by your side helping you through your case. All right. What if you have an I-751 pending and your spouse wants a divorce? What if you have a 2-year green card and you have filed for that 10-year green card by filing your I-751, but your spouse wants a divorce? Well, you've got to start looking to see if you qualify for a waiver. And if you end up getting a divorce, you may be able to amend your application by asking for the divorce waiver. And if you still can't get the divorce or you have other issues in your case, it's time to talk to a lawyer because the I-751 is so important. A denied I-751 may cause you to end up in deportation proceedings. That is not a place that you want to be. You want to get this done right the first time. So if you are facing separation or divorce in your marriage and you have only a 2-year green card, whether you have filed that I-751 or whether your 2-year green card is still valid, take action immediately and call us 2122-487-907 because we need to explore to see if we can file for a waiver for you so that you don't have to rely on your spouse, so that you can go ahead and move on with your life. And if they don't want to stay married, then you don't have to stay married, okay? All right, so that's all the time that I have for tonight. Thank you so much for asking all of your questions. Please make sure you follow me and click that notification bell and everything else that you have to do so you don't miss any more of my lives. Also, drop me questions on my videos so that when I get a chance, I'll try to do questions and answer them later. All right, everyone, have a wonderful evening.